Hello.
Hi, everyone. We're going to get started in just about 1 minute. I'm just admitting a couple more people. So thank you all for being here.
Thank you.
All right, we're going to get started. We have a couple more people joining. And so as they join, hopefully they won't miss out too much. So thank you everyone for being here. I'm excited to talk today about Femtech and the FTC and understanding the trends and the best practices that are going on in this industry, particularly as we've seen a lot of movement and new developments by the FTC in the health technology arena. So today's presentation is really designed to make sure that everyone has a foundational understanding of the FTC's role in regulating privacy and security, the ways in which the FTC uses the privacy and security authority that it has, and then also making sure that we're understanding what the FTC is looking for, how the FTC has gone ahead and regulated through investigations and settlements and joint orders, how it's actually regulating this industry and what we can learn from it. So some background about myself for those who have not yet met me. I'm Bethany Corbin. I'm the founder and CEO of Fem Innovation. Right now, we provide legal and strategic business consulting services to founders. We offer education to clinicians who are looking to get more into the femtech industry. And then our phase 2 launch will be happening in early 24. We're working to build a comprehensive platform for founders, clinicians, and investors to come and get everything they need in order to not only network, but start up their businesses. So if you're interested in being involved with our phase 2 launch, please reach out. We're looking for a lot of collaborators and partners. I've also included my email in case you have any follow-up questions from the presentation. So today's presentation has a couple of parts. If you have questions as we're going through, please put them in the chat and I will get to them at the end if I'm not able to address them as we're moving through the presentation. We're going to start first by talking about the importance of data privacy in femtech. We'll move then to the role of the FTC in regulating privacy for femtech companies. We'll look at the FTC's health breach notification rule, which also has some proposed changes that have been recommended by the FTC. There's a comment period that's open through August 8th. So that'll be something, if you're a femtech founder or company in this space, something to definitely keep an eye out because it can impact you. We'll talk about the recent FTC investigations and settlements, including the one for Premom, Flow, and then we'll also give some updates on what's going on with Kachava, which was the data broker. And then we'll talk through some lessons, trends, and best practices for femtech companies. So part one, really diving into the importance of data privacy in femtech. So for those who are very familiar with the femtech industry, you are already quite familiar with why privacy matters. Yet, despite that, femtech has often taken a check-the-box approach to privacy. What that means is that a lot of femtech companies, and this is true for health tech in general, not to pick on femtech, but they view privacy as more of an afterthought than as something that should be integrated into product development at the outset. So privacy actually has a lot of benefits for companies that we'll talk about, but it's that foundation of trust amongst your clients, your consumers, and your vendors. What that particularly means, though, is that especially in this post-Dobbs environment, if you are not prioritizing privacy, then you're already at a disadvantage with your consumers who have a lot of mistrust for this industry because they are afraid about how their data could find its way into the hands of law enforcement officers. I will tell you, I have spoken with a lot of investors and they have said, we have always prioritized privacy, but it was privacy with a little p. Now that we are in a post-Dobbs environment, we look at privacy with a capital P, and that's something that we're actively looking at whenever we're doing due diligence for our deals. So even if you're not concerned with privacy from a consumer perspective, from a funding perspective, it's absolutely essential to have privacy embedded into your products. The other thing that you'll be thinking about with privacy, which is most often what comes into play whenever I talk to founders, is a risk mitigation perspective. I don't want to get in trouble with the FTC or Department of Health and Human Services because I don't have the right privacy compliance. So access and use of identifiable data is definitely restricted by federal and state laws. And we'll talk a little bit about that landscape when we get into the FTC's role. The other thing, right, is that it's good for business. And we'll talk about this momentarily, but adding privacy and security compliance into your platform from the beginning can actually speed up the deals that you're looking to do. So specifically what I mean is there are two frameworks through which founders can look at privacy. The first most common one is risk mitigation. As I mentioned, you don't want to get in trouble with federal or state regulatory agencies. That can come not only with bad publicity, but with fines. It can also require you to implement compliance programs that you otherwise would not have to do. And that can take 3 to 5 years, and you can be under a continued investigation and having to do remedial practices for that time. So that's kind of the lens through which most founders look at it, is kind of what is the bare minimum that I need to undertake in order to reduce my risk exposure. I would encourage you to think about privacy through a different lens, which is how can I use privacy to my competitive and commercial advantage? What I mean by that is that privacy can actually help you expedite deals and get more funding. I mentioned previously how investors are now looking at privacy with that capital P, but also if you think about your long-term business plan and who you want to partner with. Are they larger healthcare organizations? Are there other industry actors who may be subject to frameworks for security like HIPAA that you might not otherwise be subject to? If so, if your plan includes partnering with them, using them as vendors, integrating into their systems, accessing their patient populations, you should automatically be thinking about A, how do I get in with them? But B, they are most likely going to have some type of privacy or security compliance requirements and assessments that you're going to have to pass before they will even consider signing an agreement with you. I've worked with companies who have not realized that, and they've gone and they've tried to set up partnerships with larger healthcare organizations. They don't have the right privacy and security frameworks already completed, and they're forced to pause that deal, and takes about 4 to 8 months to construct the required privacy framework. And that is time in which you could have already been partnering and making money with that healthcare organization. So thinking through your long-term plan and planning at least 4 to 6 months in advance to get the privacy structure that they would expect from their vendors. Right now, we are in the post-Dobbs environment. And so there are specific data risks that are unique to Femtech that don't necessarily apply to the broader health technology environment. Monetization of sensitive health data is absolutely one. And that applies to health technology in general. But the thing that differentiates Femtech is that monetization of sensitive health data includes reproductive health data. That's some of the most sensitive data that's out there. When we think about how much data goes for on the Black market, you're thinking, maybe it's not that much. Your credit card, for a reference point, goes for about $5.40 on the market. If we're talking about a health record in general, not even a health record with reproductive health data, that's about $250 on the Black market. Huge. And that's things you can't get back, right? That's your entire medical history. You can't change your medical history. It's all of your prescriptions, all of your diagnoses, your procedures. And that can be very powerful information that somebody can have in their hands as a cyber criminal. Now we have the Dobbs environment. So if you add on to that the fact that you have reproductive health data that could be used to criminalize individuals or could be used for other nefarious purposes, that is still driving the value of that health record skyrocketing high. And so as Femtech founders and as people who are working in women's health innovation, you've got to be thinking not only about just the general privacy and security for health tech, but how you're going to protect, in particular, that reproductive health data or any type of sensitive health data that you are receiving. The other thing is intimate surveillance. So with Femtech, we are bringing surveillance and quantification into areas of the life that have never had this before. As a result, we're starting to see quantification of women's reproductive health care into measurable quantities and measurable items that you can put into applications. It's always important to be thinking about privacy to make sure that doesn't get into the wrong hands. And I'm not just talking about cyber criminals, right, or nefarious third parties. There have been a lot of incidents where femtech apps or other health tech apps have been created that allow partners to access women's reproductive health data. And as a result, or to track it. And as a result, there's been gamification and other types of quantification that way that could be harmful to women. So always be thinking about who you're allowing to access that health data. And then, of course, there's data breaches, which everyone is familiar with. All right, so let's move now into the role of the FTC in regulating data privacy. And I want to use this to set the foundation to make sure everyone is clear about the regulatory agencies that are out there and the different roles that they play. Because as you know, we have quite a patchwork of healthcare and general privacy laws that impact how you can use and collect data. So at the federal level, these are the types of laws that might apply if you're running a Femtech application. You might have HIPAA's privacy and security rules. The applicability of HIPAA's privacy and security rules to your company is going to vary just depending on the type of data you're collecting and the type of entity that you are. So if you're not considered a covered entity, meaning a healthcare plan, a healthcare provider, or a healthcare clearinghouse, then, or their business associate, then HIPAA is not going to apply. Most of the Femtech apps that are on the market today, HIPAA is not applicable. So what else might be applicable? Well, you could have the information blocking rule. That's another potential one that's come into play. Again, most of the time that is coming into play from the perspective of healthcare actors. And so whether or not you're a healthcare actor is going to determine its applicability, and whether or not you're sharing healthcare data, electronic healthcare data with individuals or other entities. And then rarely 42 CFR Part 2, what that refers to are kind of your substance abuse regulations. Most of the time, those are not going to be applicable to Femtech apps. From the state law, we've seen an influx of state privacy laws. You're probably tired of seeing all the news. Oh, Washington's passing a law, Colorado's passing a law, 5 more privacy laws have been introduced. So that's what's happening on the state level, is states are coming in to fill the gaps, because as you can see, right, HIPAA's applicability is limited. And so they're coming in to fill the gaps, not only for healthcare, but privacy in general, because we don't have a comprehensive federal privacy law. We also have state consumer protection laws. That is going to be essentially the state equivalent to what the Federal Trade Commission is doing. And so I'm going to switch now to talk about the FTC, which is a federal entity, but they're doing things related to privacy on a different scale. So the Federal Trade Commission is really looking at privacy through its authority under Section 5 of the FTC Act, which is the unfair and deceptive practices. So I'll get back to that in a moment. And then the other way in which data privacy regulations could be applicable to Femtech companies, that is going to be from contractual obligations. So even if you do not have to comply with HIPAA or state privacy laws, just based on the nature of your business, you may have a vendor or a partnership that imposes those requirements on you anyway. So make sure you're looking at your contractual obligations for data privacy, because oftentimes they will be in there somewhere, and you want to make sure that you haven't agreed to anything on there that you're not complying with. And oftentimes, founders aren't necessarily aware of the types of data privacy provisions that are being put into contracts. For instance, they may be limiting your right to use de-identified data. And so that's something founders often want access to. So make sure that you're looking at your contractual obligations. Okay, so when we think about the FTC, it's not usually an agency that people automatically say, yes, that's dealing with privacy. Rather, the FTC deals generally with unfair and deceptive acts or practices in or affecting commerce. So that is a consumer protection agency, and it's making sure that companies are upholding their promises to consumers. That said, there have been increased focus recently by the FTC on how data practices and data is being collected through apps, through wearables, through non-regulated entities online. And so the FTC is taking a further increased scrutiny approach for healthcare applications, not just Femtech, health tech in general. So the way in which the FTC does this that you are probably most familiar with is going to be that privacy policy. Now, technically, privacy policy is the wrong term, but it's the term everyone uses. The correct terminology is privacy notice, because notice is an external facing consumer document, and a privacy policy is technically that internally facing document for how you as a company are going to handle data. Everyone conflates it, so it really doesn't matter, but in case you hear the terms privacy notice and privacy policy, that's actually what each is referring to. And so if you are making promises externally to consumers about how you're going to use their data, you've got to make sure those promises are accurate and truthful. And if not, that's where the FTC is going to come in, and that's where you're going to find trouble. So Section 5 of the Federal Trade Commission Act is where we have the prohibition against unfair and deceptive acts or practices. If FTC comes after a company and says, hey, we think you're in violation of this, they can issue an order, they can seek monetary damages and penalties, they can require you to implement compliance programs, they can require you to stop using data in certain ways, and they can also require you to notify consumers of any types of data breaches that have occurred. To date, the FTC has brought hundreds of actions under Section 5 for or relating to data privacy or security, and they're ramping up this activity in the health tech space now. So that's, in general, whenever we think about FTC, what they're doing with the Unfair and Deceptive Trade Practices Act. That's kind of the most likely area in which you're going to get in trouble. But we have started to see some movement now for the FTC on what's called the health breach notification rule. I want to be clear that this health breach notification rule is separate and distinct from HIPAA's breach notification rule. So they're called very similar things. They have very similar requirements, but they're two very separate laws and policies. And so even if you're not subject to HIPAA, you would potentially be subject to this FTC's breach notification rule. So what is it? Well, if you're a vendor of personal health records known as PHRs or a PHR related entity, you would have to notify consumers, the FTC, and sometimes the media, depending on the number of consumers involved, if there's a breach that involves unsecured health information. What does all that mean? We will get into it. The thing to note, though, is that the FTC is proposing to update this rule. They issued what's called a Notice of Proposed Rulemaking, an NPRM, on May 18th, and the comments are due around August 8th. So pay attention to this if you're a femtech company in this space, because these proposed modifications will impact you. Okay, so what is the FTC's health breach notification rule? Well, as I mentioned, right, if you qualify as a PHR or a PHR related entity and there's a breach of health information, you have to notify consumers. Now, you're probably not as familiar with the health breach notification rule because it was passed back in 2009, but there was very little, if at all, any activity under the health breach notification rule until this year. And the reason for that is that there were very few PHRs on the market. Now, what is a PHR? A PHR is a personal health record. And so what that means is that we have PHRs are capable of collecting information from multiple sources. And specifically, they're able, kind of like a medical record almost, right? They're able to collect information, health data from multiple different types of sources. But this definition for so long was thought to exclude any type of application, right, or platform where only consumer data was being inputted by the consumer, right? So if I'm a consumer and I'm going on my app and I'm inputting my own data, that was thought not to be a personal health record because it's not getting information from multiple sources. All the information it's getting is being manually inputted by the consumer. So for that reason, for so long, PHRs were very limited. This health breach notification rule wasn't used. Now, though, back in 2021, the FTC changed its view and it said, we are going to classify anything as a PHR if it has that technical capability or capacity to draw information from multiple sources, even if consumer inputted data is the only source. So if you have an app, for instance, right, and I'm a consumer and I'm coming on and I'm inputting my data, you now have collected my personal health information. You're now a personal health record, even though you're not collecting data from multiple sources. And the practical impact of this is that it would cover virtually all non-HIPAA regulated devices and services. So apps, platforms, websites, anything where consumers are coming in and putting their health data. It's a pretty big change, right? You go from having very few individuals covered to now you've got almost a huge health tech industry being covered here. So that change is what the FTC is seeking to implement in its notice of proposed rulemaking. And it's also proposing a couple of other changes. So for instance, the FTC is looking at authorization. It wants health apps to be required to get authorization from consumers to share their information with third parties. In addition, it would change the definition of breach. So when we think about breach, right, a lot of times people think unauthorized access by nefarious third parties, right? Cyber criminals. That's not going to be the case. The FTC wants this to broadly apply to any type of unauthorized access to an individual's health information that occurs by any third party, right? So let's say that you share that information accidentally with another person, right? With one of your vendors that wasn't authorized by the consumer. That would be a breach, and you would then have to go through the notification procedures. FTC has also proposed penalties. So the proposed penalty would be $50,120 per violation per day, obviously adjusted each year for inflation. And again, comments are due August 8th. So this is something to pay attention to. This is not, these additional proposed changes, not in effect right now, but once the FTC gets the comments, they'll review the comments, and then they will issue a final rule. I will say that the change in applicability, meaning the broader scope of PHRs, the FTC did make that kind of policy change in 2021. And so now it's seeking to kind of codify that change. So that's kind of the perspective that FTC has right now when looking at the activities of femtech companies and other health tech companies. All right, so what are we seeing in terms of FTC enforcement actions and settlements? Because there have been a few, and I'm sure that you've heard of them in the news pretty recently, especially the one for pre-mom. So these have primarily occurred under the FTC's Unfair and Deceptive Acts and Practices Authority. As I mentioned, we've seen some with pre-mom being the most recent, and I'll talk about each of these individually. We also saw GoodRx pretty recently. Flow was one that occurred back in 2021. And then we also saw the FTC go after Kachava. And Kachava is a bit different. It's not a femtech company, it's a data broker, but that's going to have implications depending on the type of femtech company you are and if you're selling or disclosing that data to data brokers. So with this landscape, let's talk about pre-mom, because that was one that was the most recent. So for those who aren't familiar with pre-mom is a free app that helps users track their ovulation, their periods, and other types of health information. And it also sells ovulation test kits. And it does this in order to provide information to these consumers about their menstrual cycles, their fertility, right, their pregnancy, and they also allow for importation of data from other apps such as Apple Health. What the FTC came in and saw for pre-mom is they alleged that pre-mom was deceiving users on a couple of different grounds. The first ground it said was that pre-mom was sharing sensitive personal information with third parties, including 2 China-based firms. Second, it said that pre-mom was disclosing users' sensitive health data to Apps Flyer and to Google. And then third, it said that the pre-mom app and the company running pre-mom had failed to notify consumers of those unauthorized disclosures of their health information in violation of that health breach notification rule. So let's unpack that. So the first couple, right, we've got disclosing sensitive user information in ways that's deceptive or unfair. What does that likely mean? Well, it likely means that pre-mom had a privacy policy that told consumers how it was going to collect, use, disclose, and share their information. it then used or disclosed their information in ways that it said it would not do or didn't otherwise not disclose in that privacy policy. So that's the kind of the first huge red flag. If you are promising consumers you're using data one way and you're using it a separate way, huge red flag for the FTC. That's going to get you in trouble very, very fast. The other thing that was really unique about this Premom case is this was only the second time that the FTC used its health breach notification rule. The first time was earlier this year with the GoodRx settlement. Now, you may be wondering, why didn't the FTC use this with Flow? So in 2021, the FTC went after Flow. And for those who aren't familiar, right, Flow is another kind of period and ovulation tracking app. And it made similar allegations against Flow. It said, Flow, you have shared sensitive health data for millions of your users with marketing and analytics firms, including Facebook and Google. Now, what makes these cases different so that the health breach notification rule was used in Premom, but it wasn't used for Flow? It's a great question. And the thing is that Flow was early 2021. So the FTC hadn't gone ahead and said that we're changing this definition of how we're looking at personal health records when Flow came into effect, when that settlement happened. The interesting thing about Flow is that you had a dissenting commissioner who basically said, you know what, it was one of those concurring and dissenting opinions, but they said, you know what, I concur. Yes, they violated our requirements for unfair and deceptive practices, but I think that they should also have been subject to the health breach notification rule. And because they weren't, why would we even have this rule? This is the exact type of situation in which it should apply. And so what happened is that kind of set the momentum for the FTC coming in and saying, you know what, this is the exact type of circumstance we're trying to correct. And because of that, what we need to do is we need to look at how our rule is applying, who it's applying to, and then we can go ahead and prosecute other companies under the health breach notification rule. So for Flow, for instance, even though it should have gone under and had a violation of the health breach notification rule because it didn't notify consumers that it used their data in ways that said it wasn't going to, it actually escaped from under that rule. When the FTC did the settlement with Flow, right, Flow had to now obtain affirmative consent from users before sharing their personal health information with others. Flow had to get an independent review of its privacy practices. It had to notify consumers about the disclosures of the health information. It had to instruct third parties that it had to delete any data that it received. It also required Flow to stop misrepresenting how it was going to use data and who it was going to disclose data to, including how much control consumers had over their data that they were giving the application. It required Flow to be upfront with its compliance with privacy and security programs. And so that was a huge kind of administrative burden to be put on a company. The thing for Flow, though, right? Flow is a well-established application, it has millions of users. This type of investigation and remedial efforts were not going to sink the company. If you're a younger startup company and this happens to you, right, you not only have the fines, right, but now you've got to implement comprehensive privacy and security compliance programs. You've got the negative publicity with it. That can be very damaging when you're trying to get your company off the ground. With Premom, for instance, what it's required to do, it's got a great, many things it has to do, but Premom is going to have to do similar things to Flow. And it's also, there have been on the kind of the security side, FTC is also alleging that Premom failed to adequately encrypt the data that it was sharing with the third parties, and that it was also sharing the sensitive and private data about individuals' sexual and reproductive health experiences. And so this is going to be pretty damaging to Premom, not only from a reputational perspective, but from a compliance, now you have to fix it perspective. With Kachava was different, as I mentioned. So Kachava is a major data location broker. So the FTC last year brought a lawsuit against Kachava, and it alleged that it was unfairly selling information on the locations of millions of individuals from their mobile phones. What that meant was the FTC was arguing that the sale of geolocation data on tens of millions of smartphones could then be used to track people's visits to private locations like churches or mosques or abortion clinics. And so that the FTC alleged was harmful and deceptive conduct. The court actually dismissed that lawsuit. It's basically said, yeah, okay, FTC, we agree with you. Even if Kachava's sale of this location data could enable third parties to track and harm smartphone users who are visiting these places, you haven't proven that there's actual evidence that consumers were actually harmed. So the FTC was given leave to file an amended complaint, which they did. So we're going to see how that plays out now in the court system. But that's interesting to watch from a data broker perspective, because a huge source of revenue for health tech companies, including femtech companies, is the use of data brokers. So a lot of times what femtech or health tech companies will do, especially those who have free applications as a revenue stream, is they will bundle, sometimes, aggregate and de-identify the data that they get from consumers and sell it downstream to data brokers. I will tell you that consumers are now much more attentive to this, and they are looking to see now in those privacy policies if companies are selling their data to data brokers. The reason for that is, as I mentioned, we're in this post-Dobbs environment in which data could be used against women who are seeking reproductive health services. So how does that work in conjunction with data brokers? Data brokers actually can sell data to anyone. You can go to a data broker and purchase data. I can go purchase data. There was a study by Vice that showed for $150, they could go and buy sensitive reproductive health information and geographic locations of people near abortion clinics for $150. What that also means is not only can anybody go and get that data from a data broker, but law enforcement can go and get that data from the data broker. And they can do that in ways in which they would otherwise need a lawful subpoena to obtain that data from the femtech company. So when you're using data brokers, keep that in mind. That's absolutely one of the keys that consumers are looking for. They, still are not reading the full privacy policies, but they are now starting to look at the disclosure section of your privacy policy to see if you're selling to data brokers. Some of the developing trends that we're starting to see for health tech applications for reproductive health data, as I mentioned, the Federal Trade Commission, increasing a focus on health tech apps, what they're doing with health data, making sure that they're being transparent and upfront with consumers. We've talked about Flow and Premon and Kachava. The other trends that we're starting to see are femtech companies starting to develop anonymous modes. Flow, I think, is the one that came out right after the Dobbs decision and said, okay, we're listening to our consumers and we've developed what we call an anonymous mode for consumers to use our health application without worrying about how their data is going to be tracked or used. I will say that there's a lot of confusion around what anonymous means. There's no technical standard that's universally adopted for something to be considered anonymous. And so consumers are oftentimes misled into what anonymous means, and that could potentially be another risk factor for unfair or deceptive practices if you're advertising something as anonymous, but you're not necessarily using enough technical capabilities that are going to make it truly anonymous. So keep that in mind. That's something that's starting to come into play. If there's any way at all in which that data could be linked back or re-identified, which there almost always is, that could potentially be seen as an unfair or deceptive practice. And then we're starting to see increased focus on legislation protecting reproductive health data. Most of you are probably familiar and have seen the abortion shield laws coming into effect. HIPAA, if you are subject to HIPAA, there was a notice of proposed rulemaking about reproductive health data and adding some protections there. So just make sure that you're keeping abreast of these developing trends within and outside of the FTC. Okay, so let's talk now about the lessons, the trends, and the best practices that we're starting to learn from these FTC developments and enforcement actions. So trends, right? As we mentioned, FTC is ramping up in this space. I hear a lot of early stage founders come and say, you know what? I don't have a lot of money to spend on privacy or security. Is that okay at this stage? Do I really need to be worried about it? Aren't they going to go after somebody who's been in the space longer, right? They're not going to come after me. I'm very small and very new. I can tell you that is the absolute wrong mindset to have, because yes, the FTC doesn't care if you're an early stage, mid stage, late stage startup. They are going to come after you if they get reports or they catch wind that you're doing something that could potentially be harmful or deceptive to consumers. So it doesn't matter your size, but that type of an investigation for an early stage company can have damaging impacts on what your consumer base is going to think about you, the trust that you have with your consumers. From a monetary perspective, if there are fines imposed, that could be a bankruptcy for your company. And so privacy and security are crucial at the early stages. And so I encourage you not to think about it as, I want to get my product to market fast, and so therefore I need to cut edges on privacy or security. Think about it as, privacy and security can really help me get these partnerships and funding that I need later on. But B, if I don't, incorporate privacy and security into my product at an early stage, this has the potential to bankrupt me and destroy my entire company. And I'm not exaggerating on that. The other thing that we've started to see as a trend is a disconnect between promises that companies are making to consumers and the actual privacy practices. And I will tell you, this is the place where most femtech companies are getting into trouble. As I mentioned, what they're saying in their privacy policies to consumers and what they're actually doing with that data, there's a misalignment. And because of that, and it may not even be an intentional misalignment. It could be, oh my gosh, we were using this Google Click ad, right, or this cookie, and we didn't realize what type of data it was collecting. Doesn't matter. What promises you made to consumers, that's what you have to stick with. And that's even if consumers never read your privacy policy, which I will tell you, 99% of consumers will never read it. Doesn't matter. Post-Dobbs, right? I've mentioned data privacy is more important than ever for consumers, for investors, for regulatory bodies. And so that should absolutely be something at the forefront. And I would encourage you to use privacy as a competitive advantage. Consumers right now, I just, right before this, I was doing a podcast with a consumer-based group, and they're fearful. I can tell you the amount of fear that's going around and mistrust for femtech industry is at an all-time high. If you're coming onto the market with something new and exciting that also has privacy protections that maybe other existing products don't, you've already set yourself apart. And I would encourage you to explain it to your audience base in a way that they can understand. There's so much legalese that's woven into privacy right now, especially privacy policies. Cut through the legalese. Right? Find an attorney, right, or another advisor who can help you sift out the legalese and make this something that a consumer can understand. Maybe you have your 10-page privacy policy, but you also have a 1-page summary that consumers could quickly glance at that allows them to become more comfortable with your product. So anything that you can do to kind of promote the privacy enhancing tech or practices that you're using, that's going to set you apart, especially if you're an early stage founder, right? And you're still building your prototype or your product. What can actually happen is you have such an opportunity to build privacy into your product at the outset that somebody who's already on the market doesn't have that opportunity to do because their product's already out there. So they're having to go back and retrofit privacy into their product in a way that you wouldn't have to do. You would have it there from the outset. Most companies are not keeping pace with privacy best practices, so keep that in mind. We'll talk about some of those best practices and which ones are pretty easy to implement. And the other thing I see from companies a lot of times is that they don't know where their data is. They don't necessarily know all the data that they're collecting, where it's being stored, who has access to it. And it's not malicious. It's just, they're busy. They don't necessarily understand how their cookies are working, right? Or how Google Analytics works or those Facebook pixels. And so they assume that they have been truthful to their consumers about how they're using their data. And they just don't recognize all the other ways in which data is going to third parties. So those are kind of the trends that I have seen from working with a lot of femtech companies, and also the trends that we're seeing from the FTC enforcement actions. What are some high-risk areas? So high-risk areas here, the number one high-risk area I see working with founders, especially those in the early stage, is copying and pasting somebody else's privacy policy. I can't tell you how many times I work with clients and I say, do you have a privacy policy? And they say, yes, I do. I got it online, or I found it off of so-and-so's product webpage. That we do the exact same thing. So I just copy and pasted their privacy policy. Terrible mistake, because no matter how similar your products are, maybe you're doing the exact same product and function, but how you use data is still necessarily going to be different than how that other company uses data. And if that privacy policy is specifically crafted to the other company, as it should be, it won't be specifically crafted for your unique needs. And so automatically, you've got a privacy policy that's not accurate for consumers, and therefore you're already committing an unfair and deceptive act or practice if the FTC were to come looking. It's almost better not to have a privacy policy at all than to have one that is not tailored to your company when you're an early stage company. So make sure that if you are at the stage where, you're collecting data, whether it's on a website, whether it's on your application or platform, that you are having an accurate privacy policy to tell consumers how you're going to use that data. Not updating privacy policies regularly. That's another huge red flag I see from companies, and I see it very often. They say, yep, I have a privacy policy. It was done 3 years ago, and yeah, we're good. The problem is, as your product grows, as your company grows, as you're doing different design elements or you're adding new features, the data that you collect, where you're storing it, who you're disclosing it to, that's all going to change, even if it only changes a tiny bit. Let's say that you add a new data category to the application, that now somebody has to input a different category of data than before. Automatically there, your privacy policy is out of date. It's not up to date and compliant. So oftentimes people want a privacy policy that they can say, yes, we have one and we've stuck it on the shelf and we don't need to revisit it. Privacy policies have to be updated regularly. I encourage you to look at them at least annually and every time that you have a new product, feature, or vendor coming onto the scene for your company. And it doesn't mean that you have to update it every single time that happens, but it means that you should absolutely review it and say, okay, we added this vendor, here's the data we're giving them. Is that covered with the language we already have? Or have we added something new or different? Okay, we've expanded and now we're collecting this new type of data. Is that already specified in the categories of data we collect, or is this something new we need to tell our consumers about? And I would do that as soon as reasonably possible after you sign the contract and you've started to implement with the new vendors or the new features. So make sure that you've got a policy or a practice for reviewing the policy procedures whenever those come into effect. We've already talked about not understanding how your company collects or uses data. And then using health data for advertising and social media. This is where companies can get into a lot of trouble. We've already started to see, and as we saw with Pre-Mom and Flow, that companies sometimes share data with analytics or advertising companies, and they are not necessarily disclosing those types of data sharing practices with consumers. So if you're using data at all for advertising or social media purposes, you want to make sure that your privacy policy and your communications to consumers reflect that. So as you're thinking through privacy for your company, right, and your product, what questions can you ask yourself? These are the questions that I recommend asking to see how well you know your privacy policies, your privacy practices, and your company's privacy stature. So for instance, when was the last time your privacy policy was updated? If it wasn't updated this year or within the last year, red flag. Do you have a data map that accurately depicts the entry and exit points for all of the data that you're collecting and storing? The answer to this should be yes. I will tell you for the majority of companies, it is no. But this is the single most important thing that you can actually do relatively cost effectively is make a data map. Show all the entry and exit points, where your data is being stored, who it's going to. And having that kind of visual depiction can help you as you look at your privacy policy and say, oh, you know what, we didn't account for data going to this vendor or data going to Facebook here through this channel or this cookie that we're using. So a data map is something you should absolutely do. I recommend doing it as an early stage company and continuing to update it just the same way that you would have to update your privacy policy every time something changes. That also is going to make it so that you know exactly where your data is. You know exactly what data you're collecting. And that's going to be very beneficial if a regulatory agency comes knocking, right? And you can say, yeah, here's all of our iterations of our data maps. Here's exactly how things are in alignment. We are on top of this. Are you collecting more data than necessary? I can tell you the answer is probably yes. And the reason for this is we live in a society in which it's thought that more data is better. And why is that? Well, the more data we have, right, the more money we can get from data brokers selling that data downstream. And I see a lot of companies saying, you know what, let's collect this data. Even if we don't know how we're going to use it yet, let's collect it and we'll figure out how we'll use it later. That's a problem because you should absolutely be adhering to the minimum necessary principle, especially if you're in the femtech or reproductive health environment, because once you've stored that data, it's your responsibility, right? So if you come in and there's a breach, oh dear, now you've got excessive data that you weren't even using that has been exposed. And so that's something to keep in mind, is making sure that at each stage, you're only collecting the data that's absolutely necessary for the operation of your product. I can tell you pretty much almost any app that's out there is not adhering to the minimum necessary collection unless it is an app that is highly privacy focused and has integrated privacy by design. Has your privacy policy been reviewed by an attorney at least once? The reason I ask this, and it's not required at all by any law or anything that an attorney help you with your privacy policy, but they will ask questions, especially, maybe it's your first draft, right? Or maybe you say, you know what, we've never had it reviewed, now might be a good time. They'll ask questions to get at, different types of data uses and disclosures that you might be missing or you might not have thought about. And they'll also know exactly what privacy language may be required depending on what state you're operating in as these new state privacy laws come into play. So just keep that in mind. It can always be worthwhile having an attorney review it at least once or once every couple of years. Do you know which vendors are using your data, right? Make sure that you've got a good understanding of your contractual obligations from a data perspective. Make sure that you understand exactly what data is going to which vendors. We've already talked about cookies, opt-in and opt-out methodologies for consumer consent. So most companies today, I will say, have an opt-out methodology, meaning they say, you know what, we're opting you into all of these features, all of the, newsletters, et cetera. You can go and opt out if you don't want to be part of it. The privacy enhancing technology really is to do an opt-in and say, we want you, consumer, to expressly opt into these functions or the sharing of your data this way. So that's going to be a more privacy enhancing option compared to opt out. And then finally, have you ever done a privacy audit during your company's life cycle? Again, most of the time, this is no for a lot of companies that I work with. But a privacy audit can be extremely beneficial because it can make sure that you're in compliance with any privacy laws that you need to be, that you have the required privacy and security practices, policies, disclaimers, disclosures, all of that in effect. It can also identify potential breaches that you may not have known already occurred, and you can take remedial action before the FTC or another government agency gets involved. And then the privacy audit can also recommend areas where you could improve your privacy functions. So those can be really helpful as you start to think through maybe your next year's plan. How can we enhance our privacy support? And think about getting a privacy audit done. Okay, so when we think about privacy workflows in Femtech apps, these are the most common workflows that companies have in place. The privacy policy, obviously, is the number one that companies are pretty familiar with. Opt-in versus opt-out consent, we've talked about. Email and text message consent. So make sure that you've got, the right permissions to email or text your customers, making sure that you've got that documented. And then consents for data sharing, right? Making sure that consumers have appropriately consented to any types of sharing of their data. Make sure that if you have an opt-in or an opt-out methodology, that consumers have opted in or alternatively have not opted out. Because if a consumer has opted out, yet maybe somehow, right, your system didn't pick up on that, right? Or there was a technical glitch or whatever, and you're still sharing their data, that's going to be a problem. So make sure that you know how all of those types of privacy workflows operate for your application. Okay, so what are some best practices? We've talked about a lot of these. The data map, That's the number one thing I recommend for early stage companies. Get that data map in place and get a privacy policy that's going to be reflective of your company at its current stage. Minimum necessary principle, right? Don't collect more data than you need. Make sure your privacy policies are transparent. And to the extent that you can and you're interested, incorporate privacy and security by design. And so you may have heard of privacy by design, but you may not necessarily know all the different elements of it. These are the elements of privacy by design. So it means you're going to be proactive about privacy, not reactive. Privacy is going to be your default setting. It's not going to be something that's an afterthought. It'll be embedded into your design. Privacy does not come at the expense of other functions or applications, right? It's not a not zero sum, right? It's a positive sum by incorporating privacy. Make sure you've got end-to-end security, full lifecycle encryption. Make sure that you're encrypting any type of data that you're sharing. Make sure that you're being visible and transparent to your customers, and keep it user-centric, right? Always think whenever you're designing your product, think about the different ways in which you as a consumer would expect your data to be protected. One thing I always recommend to companies, if you're worried about the FTC coming after you, read your privacy policy from the perspective of a consumer, right? Not from your founder perspective, not from a tech perspective. You can even have your friend read it, right? From a layperson's perspective. Is it easy to read? Do they understand what I'm saying? If I asked my friend to read this and I came and I asked her to complete a 5-question quiz, would she get it right? Would she know, like, oh yeah, which of these A, B, or C is how I'm disclosing your data? If not, you're already not being transparent and visible to your consumers. And that's something that can easily be fixed and needs to be fixed in order for the FTC to recognize that you have good privacy practices in place. And these are, just so you know, in line with what the FTC recommends for mobile health app developers. So the FTC has a list of best practices for mobile health app developers, and it includes things like minimizing data, limiting access and permissions for who on your team can access that data, keeping authentication in mind. So for example, how is your app generating credentials? How are you verifying credentials? Consider the whole mobile ecosystem, right? Research the different types of mobile platforms that might be available and adapt your company's code to protect personal data. Implement security by design. And then also don't reinvent the wheel. So as founders, I know it can be extremely difficult to keep track of everything, right? And it's overwhelming. But there are low cost and free tools that are out there that you can incorporate into your platform and into your company to safeguard personal information and protect privacy. So for instance, there's software development kits, software libraries, cross-platform toolkits, all these types of things that are free. They can help you provide encryption. They can help you do like pre and post-launch testing. So don't feel like you have to reinvent the wheel. There are things out there. Take a look and see what you're able to find. And then don't forget about the other applicable privacy laws. What I mean by that is, if you're collecting data or information from children under 13, then you should know about applicable laws like the Children's Online Privacy Protection Rule or Act, COPA. State laws, understand basic truth in advertising and privacy principles. So we've talked just today about the FTC, but there's a lot of other laws and regulations out there that, depending on how you're operating, may be applicable. So I know that we have covered quite a bit of territory today. If there are any questions, please feel free to put them in the chat and I am happy to answer them. If you have follow-up questions that you don't want to ask here, I have included my contact information, including email, my LinkedIn, my website. I regularly post about privacy and security on LinkedIn, so that's a great place to follow for new resources that come out and new advice for founders. So if there's anything that I can help with, please let me know. Please post questions. And if not, I hope you have a great day. Thank you.